Committee will come to order. We're going to try to move this hearing along today because we have a 11 o'clock bill which is being taken up on the floor that many of the members of the Judiciary Committee will be involved in. So we're going to try to move this testimony along today. Mr. Scott, I was just mentioning that at 11 o'clock we've got this committee has a bill that we'll be involved with on the floor, so we're going to try to move it along fairly quickly today. I want to thank all the members for being here. I'm Steve Shabbat, the chairman of the Subcommittee on the Constitution. The NCAA is a voluntary organization comprised of some 1,200 member schools from 50 states. Many of these member institutions are public colleges and universities. The NCAA's goal is, quote, to initiate, stimulate, and improve intercollegiate athletics programs for student athletes, unquote. To this end, the NCAA conducted 87 championships in 22 sports across 3 divisions in the 2002-2003 school year. That year, over 375,000 student athletes competed in NCAA sports. One way the NCAA serves to initiate, stimulate, and improve intercollegiate athletics is by passing and enforcing rules to ensure the integrity of the sports experience. The rules, which are promulgated by its member institutions, govern, among other things, recruiting, amateurism, and academics. The rules are published in each division's bylaws. The Division I bylaws for 2004-2005 consist of some 457 pages. The NCAA enforces these rules with its own paid professional staff and a voluntary committee on infractions, which is comprised of representatives from its member institutions. The details of how the NCAA enforces its rules are quite complicated, and we are very fortunate to have Joe Patudo, Vice Chair of the NCAA's Committee on Infractions, here today to explain how the rules work in practice. In brief, infractions are divided into major and secondary violations, and the amount of procedure to which an institution, coach, or student athlete is entitled depends on the category of infraction in which the violation falls. Additionally, student athletes who are found to be ineligible for any reason are subject to the NCAA's reinstatement process if they want to regain their eligibility to play college athletics. Let me state at the outset what this hearing is not about. It is not about the wisdom of any particular NCAA substantive rule, nor is it about the NCAA's authority to enforce its rules. The NCAA provides a valuable function in policing collegiate athletics, and we are not here to relitigate any particular decision that the NCAA has made. This hearing is about fairness, particularly the fairness the NCAA displays in enforcing its rules. Merited or not, the NCAA has at least the perception of a fairness problem. Evidence of this is found in newspapers, such as stories regarding the NCAA's decision not to restore eligibility to Jeremy Bloom, who is with us today, and Mike Williams. It is found in courtrooms where 2 former Alabama assistant coaches have sued the NCAA for alleged violations of procedural due process. It is also found in state legislatures, such as the state of Nevada, which passed statutes providing particular due process rights for NCAA investigations conducted within their states. And it is found in the NCAA's own 1991 study, conducted by former Solicitor General Rex Lee, which proposed 11 recommendations the NCAA should undertake to improve fairness in its procedures. It has been 13 years since Congress last examined the procedures that the NCAA uses to investigate and enforce its rules. In that time, the NCAA has made several changes, most notably the addition of a more robust appellate system for major infractions cases that have provided greater protections for member institutions, coaches, and student athletes. However, the NCAA has failed to take action on several recommendations of its own 1991 study, most notably those relating to the hiring of independent judges to hear infractions cases and the opening of these proceedings to all. This hearing will examine those recommendations and the NCAA's decisions not to implement them. We will also examine the investigated individual's role in the process and their ability to participate fully in it. And we will examine the NCAA's restitution rule, which punishes member institutions in the event that student-athlete initiated litigation is ever resolved in favor of the NCAA. I would like to thank Congressman Baucus for requesting this hearing, and also Congressman Osborne for his interest in this area. I'm sure that many of us will look to Tom Osborne for guidance in this particular area, as Congressman Osborne is uniquely qualified, having coached for 36 years the Nebraska Cornhuskers football team. I might note taking his team to a bowl every season and averaging 10 wins per season. So Congressman Osborne is some that we all look to around here when it comes to particularly college athletics. I would also like to thank for their cooperation with our staff and for their willingness to appear before this subcommittee to discuss their procedures. Finally, I appreciate, we all appreciate our other witnesses' attendance here this morning, and we look forward to hearing from all our witnesses. And I would now yield to the gentleman from New York, the ranking member of this subcommittee, Mr. Nadler.
Thank you, Mr. Chairman. Mr. Chairman, I want to thank the witnesses for coming here on such short notice. I had not realized that issues involving the NCAA enforcement procedures were such an urgent matter. I had not, in fact, realized that the procedures of the NCAA came within the jurisdiction of the Subcommittee on the Constitution. Now, due process does come before, does fall under the jurisdiction of this subcommittee, but that's generally due process by the United States government, not due process by a private organization such as the NCAA. Perhaps, however, it does come under the jurisdiction of this subcommittee because I know that in many communities, college sports are the nearest thing we have to an established religion. I would hope that in the last few weeks of this Congress, our subcommittee will be able to make time for some other pressing issues that plainly implicate the constitutional rights of millions of Americans. For example, I know that our colleague, the gentleman from Virginia, has been working with the majority in this committee for some time, trying to get an oversight hearing on the extent to which the Department of Agriculture, despite a consent decree, is still violating the rights of African American farmers and forcing some of them off their land. I would also hope that we could take time from our busy schedule to examine whether citizens are again being illegally stripped of their right to vote. I wouldn't even object if the Bush Justice Department could answer our written questions from the March 2nd oversight hearing on the Civil Rights Division, or if we could get the overdue report from the privacy officer security in office this committee established. I hope that the chairman of the subcommittee and of the committee will agree to work with the minority in some of these issues, and perhaps we can agree that these are issues that deserve consideration and time before the playoffs. I apologize to the witnesses before this subcommittee. Unfortunately, in the crush of business at the end of this Congress, on matters such as funding the federal government, reform of our intelligence agencies, and other matters, I will not be able to stay for most of the hearing. I know that this is an important issue to many sports fans. I have the testimony. It will receive my attention, but I apologize for not being able to stay for most of the hearing. Thank you, Mr. Chairman.
Thank you. I'm not going to respond to everything that you said in your opening statement, but relative to the issue of the black farmers, there is a hearing set for September 28th. So,
I'm glad to hear it.
Okay. The gentleman from Alabama, Mr. Baucus, is recognized for the purpose of making an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, if you go back to the Magna Carta, 1215, the principle of due process was first at least discussed openly in England and embodied in the Magna Carta. Over the next several hundred years, certain things became basically acceptable. One of those things was open hearings. When people were deprived of their freedom, of their property, an open hearing was granted. Some of you may have heard of England. Our NCAA representative teaches constitutional law at the University of Nebraska. The Star Chambers were originally, sessions were open to the public. However, under Charles I and other kings, they began to misuse their power, abuse their power. And one of the first things they did was to take away the public hearings. They explained that away by saying it was expedient and saved time. And also there was too much trouble to allow the public to come in. If you look at the Supreme Court decisions, and I have several which I'll submit to the record, but the Supreme Court makes it clear that not only in criminal procedures, but in civil procedures, that our citizens should enjoy due process. They talk about independent triers of the fact, public hearings, right to confront the witnesses and know the witnesses against you, that those should apply in all civil matters of importance as well as criminal matters. How does that apply to the NCAA, a, quote, so-called voluntary organization? Well, first of all, and I've heard the chairman, I've heard others talk about a voluntary organization. I think that anybody that has studied the NCAA readily realizes that the athletes are not members, nor are they invited to be members, but the great number of decisions, they affect more athletes than anyone else. Athletes are not members. They have no input, but they are controlled. In fact, that's why the Harvard Business School said that the #1 monopoly in America is not Microsoft, is not Walmart, is not the West Coast Longshoremen's Union, is not the post office, is not even OPEC. They said it's the NCAA, which has total power and abuses that power. They also said this, that the NCAA, with the NCAA in charge, the student remains poor. With the NCAA in charge, the student remains poor. They talked about the NCAA trying to maintain the high ground, but not doing a very good job of it. And they pointed out, as did the NCAA, and this is maybe my last important point, and really the main point of this hearing. The NCAA itself looked at their procedures. They assembled a Supreme Court judges, a Solicitor General, a former Attorney General, several law school professors, and they studied how can we better improve our system of enforcement. And I'm going to submit 3 articles from 1991 and 92. They agreed that 2 things they ought to do, and this was their own committee. They agreed they ought to have public, open hearings. And I can cite from Justice Marshall numerous, over 100 Supreme Court cases that talk about the importance of letting the sunshine in. And it's very unique that you'll see the explanation of the witness for the NCAA and the reason that she gives for not having opening hearings, a rather unusual reason. But they said that. They said they ought to have the right to confront witnesses, and most importantly, and the cases are very clear on this, an impartial trier of the fact. Well, you know, these 1991 and 92 articles say the NCAA is going to adopt those, and it's going to take the pressure off of them from congressional hearings, court hearings, legislatures, the public, which has demanded these things. Guess what? They didn't do it. The 2 most important, according to the USA Today, the 2 most important reforms they have failed utterly to do. And who has been victimized by this? It is the student athlete. You'll hear from one of them today. And I can tell you that the longer you study this, you realize that the NCAA and sometimes the member institutions trade off, and those that lose are those without power, the coaches, and more often than the coaches, the athletes who are victimized by this system. $485 million a year in revenue goes into the system, yet the NCAA says it cannot afford to give due process, something that our common law tradition has been with us for hundreds of years. But that tradition is not in the NCAA. And with that, Mr. Speaker, I'll yield back any time that I have. But I also think that, say in closing, Tom Osborne does have one good suggestion here that he makes to this committee, and that's let's do something for the athletes. A lot of the problems with these cases is the athletes are given scholarship money, but not money to live on. And he says, and as the Harvard Business School says, and as the NCAA has said, most of these students are very poor, and it's very hard for them to even pay for their cost of living. Yet the NCAA has really led the fight against a lot of things for athletes, including compensating them at least for their living expenses.
The gentleman's time has expired. I would note that Congressman Osborne just entered the room. He missed all the flattering comments that I made about him, unfortunately. But in any event, we're very happy to see you here today. Are there any of the minority members who want to make an opening statement beside the ranking member? If not, any opening statements could be made part of the record. We'd now like to turn to our witnesses for today's hearing. Our first witness is Jeremy Bloom, a U.S. Olympic skier and former University of Colorado football player. Mr. Bloom has been a member of the U.S. Olympic ski team since he was 15 years old and represented the United States at the Salt Lake City Winter Olympics in 2002. He is the youngest person to win the World Grand Prix title and the first American to win a World Championship gold medal in mogul skiing. Mr. Bloom is also a gifted football player and holds a number of receiving, punt return, and kick return records at the University of Colorado. Our second witness is Josephine R. Joe Patuto, Vice Chair of the NCAA's Committee on Infractions, and Richard H. Larson, Professor of Law at the University of Nebraska College of Law. Ms. Patuto earned her bachelor's degree from Rutgers Douglas College and her JD at the Rutgers College of Law in 1974. In 2003, Ms. Patuto was selected to be on the NCAA's Division I Management Council, the chief administrative and legislative body of Division I. She is in her 6th year as a member of the Division I Committee on Infractions and her 2nd as committee vice chair. At the University of Nebraska, she teaches courses on constitutional, procedural, and criminal law, as well as a course in sports law. Our third witness is Dr. B. David Ridpath, Assistant Professor of Sport Administration at the Mississippi State University. Dr. Ridpath is the former compliance officer at Marshall University in West Virginia. Our fourth and final witness was to be Gary R. Roberts, Deputy Dean and Director of the Sports Law Program at Tulane Law School. Unfortunately, because of Hurricane Ivan and the fact that it's veered close to New Orleans, where Tulane is located, Mr. Roberts had to cancel at the last moment. He has submitted written testimony, however, which will be put into the record. I would also note that without objection, all members will have 5 legislative days to submit additional materials for the hearing record. And it's the practice of this committee to swear in all witnesses appearing before it. So if the witnesses would please stand and raise your right hand. Do you swear that the testimony that you're about to give, that you will tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much, and you can please be seated. We do have a lighting system here. As you might have noted, there's 2 boxes on the desk there, and each witness is allowed 5 minutes to testify. When 4 minutes have gone by, a yellow light will come on, tells you got 1 minute to wrap up. When the red light comes on, we'd appreciate you wrapping up at that time. We'll give a little leeway, but we'd appreciate you trying to stay within the 5-minute rule, and then the members of the panel here will have 5 minutes to question each of the witnesses. And we'll begin with you, Mr. Bloom, if you would testify for 5 minutes.
Distinguished members, I'm honored to testify in front of you today. I'm a former student athlete, and I intend to give all of you perspective into personal experience with the current procedures and practices of the NCAA. The current procedural system for a student athlete to dispute interpretations of the NCAA bylaw is flawed. In the United States, when there is a conflict, a dispute, or disagreement between 2 parties, fairness is ultimately judged by our peers or by an impartial court proceeding. In the NCAA, the judgment of the dispute is formed exclusively within their organization by their own members. They're the judge, the jury, and the executioner. And although they may be a voluntary organization for the institutions, they don't give the student athlete much of a choice but to become a member. For instance, if any person aspires to play professional football, they effectively must take part in the NCAA.